The Supreme Court on Thursday continued to hear the challenges to the reservations for economically weaker citizens and the Karnataka's hijab ban in educational institutions. In the Chief Justice's courtroom, advocates continue to explore different points of view to convince the Constitution bench that reservations based solely on economic criteria are not valid. Advocate Shadan Farasat argued that reservations were a tool provided solely to combat discrimination and not to help people who are economically deprived. He contemplated that even if there is a reservation to combat economic deprivation, the backward classes, who are the most economically deprived, must benefit from it. Excluding them is against the concept of equality, a pillar of our Constitution. Mr. Farasat argued that the inclusion of a group in one reservation cannot mean exclusion in another. He stated that the logic of reservation is defeated when it is provided to an individual as opposed to being provided to backward classes as a group. He added that the position of a person within a group, economically or otherwise, is irrelevant. He stated that the poor among the backward classes are worse off than the poor among the forward classes. Mr. Farasat argued that backward classes are more likely to be poor in India and experience poverty in a deeper, more intense and persistent way. Citing data, he told the bench that poverty is multidimensional and most people who experience poverty to such an extent are SC/STs or OBCs. Senior advocate Gopal Shankar Narayanan, who appeared towards the end of the day's hearing, argued that EWS as a concept should not really be frowned upon. However, he told the bench that Article 16(6), which exempts backward classes from availing EWS reservation, is against the basic structure of the Constitution. He will elaborate his arguments on Tuesday next week. Meanwhile, a bench of Justices Hemant Gupta and Sudhanshu Dhulia heard a long list of lawyers who argued against Karnataka's hijab ban. Opening the arguments today, Senior Advocate Jana Kothari used the concept of intersectionality to demonstrate how the ban discriminates against Muslim women on the basis of both their religious and gender identity. She argued that there is no need to assess if hijab is essential to Islam, as the Constitution grants the liberty to profess, practice and propagate religion of one's choice. Referring to the Supreme Court's judgment in Patan Jamal Wali v. State of Andhra Pradesh, Ms. Kothari argued that discrimination caused by intersecting identities, that is gender and religion, amplifies violence against certain communities. Arguing against the ban, Advocate Shoaib Alam cited the Supreme Court's judgment upholding the right to privacy as a fundamental right, to say that to dress as one pleases is a part of dignity, and the right to dignity vests in a person, not a place. Mr. Alam referred to a host of landmark judgments of the Supreme Court to argue that education is a fundamental and socio-economic right, and the state has a responsibility to ensure access to education. He argued that no citizens can be made to barter one's right for another. The hijab ban forces Muslim women to trade their right to religion for their right to education. Hearings in the challenges to EWS reservations will continue on Tuesday, where the bench will continue hearing Senior Advocate Gopal Shankar Narayanan. The hijab ban challenges will be taken up for hearing on Monday at 2 p.m., where the bench will hear Senior Advocate Dushyant Dave. For more, visit scobserver.in.